Good afternoon. My name is John Goodin, and I am the Director of EPA's Office of Wetlands, Oceans, and Watersheds. My role is to serve as moderator for today's meeting. I want to thank you for your time and your interest in this Waters of the U.S. webcast. The EPA and the Department of the Army published today in the Federal Register a proposed rule that would revise the regulations defining waters of the United States that are subject to Clean Water Act authority. The agency's proposal would provide a straightforward definition of waters of the U.S., intended to protect the nation's waterways, help sustain economic growth, and provide for regulatory certainty. The agencies are hosting this webcast to help explain the key elements of the proposal and to help with your understanding of the proposed rule as you consider submitting comments to the agencies. Note that the public comment period will end on April 15th. This webcast will be recorded and hosted on the agency's websites for later review. The agencies encourage participants to submit comments through the official docket for this rulemaking. I will now introduce leaders from EPA's Office of Water and the Department of the Army to make some brief opening remarks. First, let me introduce Mr. Lee Forsgren, Deputy Assistant Administrator for EPA's Office of Water. Lee?
Thank you, John. And I want to thank the many people who made the effort to join us today. How waters of the United States is defined is of great interest to our stakeholders. And there's certainly been a lot of interest in how the agencies are responding to the February 28, 2017 Presidential Executive Order 13778 on restoring the rule of law, federalism, and economic growth by reviewing the waters of the United States rules. I'm pleased to note that we continue working very closely with our partners in the Department of the Army as we've engaged in this rulemaking regarding the definition of the waters of the United States. The agencies are committed to an open, transparent process for reviewing the definition of waters of the United States. Throughout this rulemaking process, the agencies are striving to produce a rule that stays within the legal limits provided to us by Congress, properly balancing the federal and state relationship over land and water resources while protecting the nation's waterways and providing for the regulatory certainty and predictability. We look forward to a robust and illuminating public comment period. And with that, I'll give it back to John.
Thank you, Lee. I'm now pleased to introduce Mr. Ryan Fisher, Principal Deputy Assistant Secretary of the Army for Civil Works. Ryan?
Yeah, thanks, John, and thanks, Lee, for those opening comments as well. As John said, I'm Ryan Fisher. I'm the Principal Deputy Assistant Secretary of the Army for Civil Works. My boss is R.D. James, the Assistant Secretary of the Army for Civil Works. I'm on this call on his behalf. I want to thank everybody for joining us. We here at the Department of Army, which includes the Corps of Engineers, are working closely with EPA on these rulemakings to help improve the clarity in defining waters of the United States. In supporting EPA in this effort, our objectives here at Army are to bring a common sense approach to the definition. We want to make implementation clear and predictable. Along those lines, we also want to reduce inconsistencies in implementation across the nation. And we certainly recognize and respect the primary authority of states and tribes have over their own waters. And lastly, of course, we want to balance protecting federal waters with the need to support national economic interests. We believe simply that having a clear and understandable definition creates a more efficient process for the Corps to make jurisdictional determinations and thereby get predictable decisions on when permits are required to the public quicker, which will allow necessary economic growth to move forward. As Mr. Forsgren mentioned, input from the public is critical in this situation in helping us to successfully meet these objectives and implement our regulatory programs. We're pleased to join EPA today in providing you this update. For my boss's tenure, for Mr. James's tenure as Assistant Secretary, his overall goal here is to improve the efficiency and consistencies within the core regulatory program. This proposed rule takes a large step in moving us toward that goal. Now, due to the uncertainty caused by recent litigation, for those currently seeking approved JDs during this rulemaking process to determine the presence or absence of waters of the United States, we are committed to providing a transparent and updated information as possible on an ongoing basis regarding which rules are in place in which states. Today, we certainly look forward to hearing more from you going forward as we further engage with you on this proposed rulemaking. Thanks again to EPA for hosting, and thanks to everybody here for joining us today on the phone. Thank you.
Thank you, Ryan. I will now turn the webinar over to Ms. Mindy Eisenberg, Associate Director of EPA's Oceans, Wetlands, and Communities Division, for some details on the proposal. Mindy?
For today's presentation, I'll provide a background on the overall rulemaking process, walk through the elements of the proposed rule, and highlight some differences compared to the 2015 rule and pre-2015 practice. I'll also describe the two key supporting documents for this rulemaking and cover some immediate next steps. So as Lee mentioned, the President issued an executive order in February of 2017 directing the EPA and the Army to review the final 2015 rule and publish for notice and comment a proposed rule rescinding or revising that rule. The text of the executive order is available on our website, and we have been following it since that time as we consider waters of the United States. The agencies are pursuing a two-step process in implementing the executive order. We refer to the Step 1 rule, which is the proposal to repeal the 2015 rule and recodify the prior regulations. The agencies published a proposed rule in July of 2017 and then a supplemental notice in July of 2018. We are currently reviewing and considering the comments received on these two notices. Our Step 2 proposed rule, which is in the which was published today in the Federal Register, is intended to revise the definition of waters of the U.S. It was signed by the two agencies on December 11th and is available on our website. Today's presentation focuses on this proposed rule. In addition to the Step 1 and Step 2 rules, the agencies finalized a separate rule a year ago to add an applicability date to the 2015 rule, which would make it not effective until February of 2020. Therefore, the agencies would continue to implement the regulatory text that existed prior to the 2015 rule, as consistent with the 2003 SWANK guidance and the 2008 Rapanos guidance in light of those two Supreme Court decisions. I will be referring to this as pre-2015 practice throughout this presentation. Since February 2018, there has been litigation in several district courts on this rule. The district court in South Carolina enjoined and vacated the rule nationwide, and a Washington district court vacated it nationwide. This means there is now a split across the country of where the 2015 rule applies and where the pre-2015 practice applies, because earlier, several courts issued preliminary injunctions against the 2015 rule. To help the public, the agencies have posted a map on our WOTUS website to show which rule applies across the country. As the agencies embarked on this effort to revise the definition of waters of the U.S. in 2017, we had a series of key goals, which Ryan and Lee have noted, that we've been considering as we've been developing this effort. Obviously, we've been responding to the executive order and the elements within it. We've been striving to provide clarity and predictability in the descriptions of what is and what is not a water of the U.S. And we've been trying to strike a proper balance between the regulatory authority of the federal government and state and tribal primacy over their land and water resources, and adhere to the overall structure and function of the Clean Water Act. We have sought to also operate within the legal limits established by Congress as clarified by the Supreme Court, particularly in the three key cases involving waters of the U.S., Riverside Bayview Homes, Swank, and Rapanos. In the preamble, you will see each of these goals discussed in further detail. There are three sections of the proposed rule. The first is what is proposed to be a water of the U.S. The second section is what would be excluded from the definition of waters of the U.S. And then finally, a series of definitions of key terms used throughout this rule. We solicit comment throughout the proposal as well as on the supporting documents, the resource and programmatic assessment, and the economic analysis. The agencies encourage you to read through these documents carefully and consider the numerous issues for which we solicit comments. I also want to point out that the definition of waters of the U.S. is currently found in 11 sections of the Code of Federal Regulations because it applies across many Clean Water Act programs. The agencies are also soliciting comments on including the definition just once in EPA's regulations and once in the Corps of Engineers regulations. The agencies are proposing 6 categories of waters of the U.S. I'll discuss each of these before discussing what the agencies propose to not be waters of the U.S. In the preamble, we also discuss how we could implement each of these categories and the definitions on the ground. We start with traditional navigable waters, which are large rivers and lakes and waters subject to the ebb and flow of the tide. These are foundational waters that have historically been regulated by the federal government under the Commerce Clause of the Constitution, which gave Congress the authority to regulate channels of interstate commerce and therefore its commerce powers over navigation. The Supreme Court has further clarified that this authority could be extended to non-navigable tributaries as necessary to protect these channels. The slide provides the definition of traditional navigable waters. The agencies are not proposing to change the meaning of a TNW. One difference from the 2015 rule and the prior regulations is that we would propose to add the territorial seas to this category rather than retaining it as a separate category. You will see connections back to TMWs throughout the other categories of waters of the U.S. where they contribute flow or are connected to TNWs, including adjacent wetlands. The agencies are proposing a second category of jurisdictional tributaries to TNWs that reflects a wide variety of pre-proposal input. There are a number of elements to this proposed category to identify what is jurisdictional and what would not be, so I encourage you to read the preamble for further discussion. You can read the definition on this slide, and I'd like to emphasize that this is a regulatory definition and it may differ from scientific definitions of tributary. Some of the key points about the tributary definition I'd like to highlight. The first is the use of a significant nexus analysis for making case-specific determinations is eliminated in this proposed rule through the categorical inclusion of these tributaries. The agencies are focused on relatively permanent waters that contribute perennial or intermittent flow in a typical year. Each of these terms are defined in the proposed rule, and we discuss in the preamble how they might be implemented. Typical year is a key term defined in the proposal and is used in the tributary definition as well as in other categories in this rule. We propose typical year to mean within the normal range of precipitation over a rolling 30-year period or a particular geographic region. This is intended to account for regional variation in precipitation across the country. A key difference with this proposal compared to the 2015 rule and pre-2015 practice is that it would exclude all ephemeral features, meaning those that flow only in direct response to precipitation. These would be excluded from the definition. The agencies would therefore not apply federal jurisdiction to these ordinarily dry features. The definition captures instances where a tributary flows through artificial or natural breaks or features, so long as it continues to convey perennial or intermittent flow to a TNW. They would remain jurisdictional throughout. For example, if a stream flows through a boulder field or a wetland and continues to flow beyond that field or wetland down to a traditional navigable water, it would remain jurisdictional throughout. An important element of this provision is that the tributary would no longer be jurisdictional if the perennial or intermittent flow does not reach a TNW. For example, if the tributary flows into an ephemeral feature the feature would then sever jurisdiction with that upstream water. I also want to note that if a tributary is altered or relocated and still meets the flow characteristics and connection in this definition, it would be jurisdictional under the proposed rule. This is consistent with the agency's longstanding position that if a river or stream has been straightened, widened, or moved, it doesn't lose its jurisdictional status. And finally, the agencies are soliciting comment on a number of aspects related to the definition of tributary, as well as definitions for perennial, intermittent, snowpack, typical year. There are also alternative constructs and implementation methods and tools for distinguishing flow regimes, as well as our proposed interpretation of the respondents' opinions as it applies to tributaries. In the proposed rule, the agencies have proposed a separate category for jurisdictional ditches in an effort to provide greater clarity on how ditches should be treated rather than including it in a tributary category. This, along with other aspects described in the preamble, is a different approach from the 2015 rule and the pre-2015 practice. Under the proposal, there are only 3 types of jurisdictional ditches. Those that, such as a canal used in interstate commerce that meet the definition of a traditional navigable water, ditches constructed in a water that meets the definition of tributary, which could include an altered tributary if it is used to convey water, and a ditch constructed in a wetland that meets the proposed definition of adjacent wetland and satisfies the elements of the definition of tributary. I'll talk later about ditches that would not be considered jurisdictional under the proposed rule when we cover exclusion. The agencies welcome feedback on whether we should treat ditches as a separate category and how this approach might be implemented on the ground, including what information would be used to determine if a ditch is jurisdictional or not. The agencies are proposing for the first time a separate category of waters of the U.S. for lakes and ponds in an effort to provide clarity. There are 3 instances where they would be jurisdictional. The first is a traditional navigable water, which is no change from the 2015 rule or pre-2015 practice. The second is similar to the tributary category, where a lake or pond contributes perennial or intermittent flow to a TNW in a typical year, either directly or indirectly through another water of the U.S. or certain excluded features. The third element is similar to adjacent wetlands, which I'll come to shortly, in that the agencies are providing for jurisdiction over lakes and ponds that are essentially so close to another water of the U.S. that they receive flood waters in a typical year. This is very different from a pond that might be found at a distance in a 100-year floodplain of a river. We're soliciting comment on whether we should have this separate category for lakes and ponds, or if they are adequately covered under the tributaries category, TNWs, or the impoundments category, as well as how we could define lakes and ponds. Our next category of jurisdictional waters is impoundments. This is a long-standing category in the agency's regulations and is based on the premise that if you impound an otherwise jurisdictional water, it retains its jurisdiction under the Clean Water Act. So if you dam a perennial tributary to create a reservoir, that reservoir would still be jurisdictional. We are not proposing a change. However, we do solicit comment on the value of retaining this category, or if it is adequately covered under one of the other categories. And we solicit feedback on how to address scenarios where the physical connection to another jurisdictional water might no longer exist, or the flow of, say, a reservoir is limited to only a couple of times a year. The final category of waters of the U.S. is adjacent wetlands. The agencies are not proposing a change to the existing regulatory definition of wetland, which is different from the scientific definitions of wetlands. The framing of this category is that certain wetlands are waters of the U.S. because of their connection to other waters of the U.S. and affect the traditional navigable waters. With that in mind, the agencies are proposing that wetlands are adjacent and therefore jurisdictional where they abut or have a direct hydrologic surface connection to another water of the U.S. in a typical year. For purposes of the proposed rule, abut means when a wetland touches a water of the U.S. at a point or side. A direct hydrologic surface connection may occur due to inundation from a jurisdictional water, such as a jurisdictional lake or tributary, or via perennial or intermittent flow between a wetland and a jurisdictional water in a typical year. For example, if during the annual rainy season the groundwater table rises such that there is a seasonal surface connection between a wetland and a tributary, that wetland could be considered adjacent and therefore a water of the U.S. Where wetlands are physically separated by uplands, dikes, or other features like a road, and there is no direct hydrologic surface connection between the wetland and another water of the U.S., such as through a culvert or tide gate, that wetland would not be jurisdictional. The agencies are soliciting comment on the various aspects of this proposed category and definition, including what tools could be used to determine whether a direct hydrologic surface connection exists. There are several differences between the proposed rule and the 2015 rule and pre-2015 practice, including the proposed elimination of the case-specific significant nexus evaluation for determining the status of a wetland and eliminating the neighboring concept. The agencies are proposing to not include interstate waters as a separate category. Only where a water that crosses state lines otherwise meets the conditions of one of the 6 categories of WOTUS proposed would be jurisdictional under this proposed rule. This is a difference from the 2015 rule and prior regulations, and the agencies discuss our rationale and solicit comment on this approach in the preamble. So we've just walked through what are proposed to be waters of the U.S., and now we'll turn to what the agencies are proposing to not include as waters of the U.S. We shorthand these as exclusions, as they would be categorically excluded from the definition of waters of the U.S. I do want to point out that this is different from exemptions, which are waters that would otherwise meet the definition of waters of the U.S., but are exempt from Clean Water Act permitting, such as the maintenance of drainage ditches under Section 404F of the Clean Water Act. The proposed rule does not specifically address exemptions. So the agency's approach for exclusions as a starting point is that if it is not covered by one of the 6 categories of WOTUS, then it's excluded. We then articulate additional exclusions to provide clarity, incorporate exclusions that the regulated community is familiar with, and to further define certain exclusions from the past. It's not intended to be an exhaustive list. We are therefore trying to avoid an exhaustive list of all possible features, and do not want to imply that if you don't see a particular exclusion, that it is therefore a water of the U.S. Therefore, we start this section with this first exclusion. The agencies are proposing to exclude groundwater, which has never been considered a water of the U.S. We are also clarifying that even when groundwater is channelized through subsurface drainage systems like tile drains, it would be excluded. This is no change, as I said, from the 2015 rule and pre-2015 practice. The next exclusion is for ephemeral features and diffuse stormwater runoff. This exclusion aligns with the proposed tributary category, which requires perennial or intermittent flow in order to be found jurisdictional. And so this exclusion reinforces that ephemeral flows and features defined as water flowing or pooling only in direct response to precipitation are not waters of the U.S. And as I noted earlier, this proposed rule does differ from the 2015 rule and pre-2015 practice, where some ephemeral streams may be found jurisdictional. The exclusion for certain ditches is the counterpart to those that are found to be jurisdictional under this proposed rule. And as a reminder, a straightened stream or relocated stream that meets the definition of tributary could still be found jurisdictional, even if it is considered ditched. Excluded ditches include those that are entirely man-made unless they are for interstate commerce, including tidal ditches and canals. The exclusion also captures those ditches that may have been originally constructed in a stream, but there is no evidence to show that it was originally a stream. I do point out that the burden is on the government to demonstrate that it meets the conditions of a tributary as defined in this proposed rule in order to be found a jurisdictional ditch. As the preamble notes, ditches that are not waters of the U.S. may be point sources. Therefore, a facility discharging to a feature that meets the exclusion for ditches may still need an NPDES permit if the ditch then flows into a water of the U.S. In comparison to the 2015 rule and pre-2015 practice, this proposal would exclude more ditches. The agencies are proposing to exclude prior converted cropland. This continues the long-standing exclusion for PCC. We are proposing two major changes in this rule. First, we're proposing a definition of PCC for the first time in rule text. And we are clarifying when prior converted cropland would no longer be excluded under the Clean Water Act. Specifically, if cropland is abandoned and it has reverted to wetlands that meet our regulatory definition of wetlands, it may be found jurisdictional. The term prior converted cropland means any area that prior to December 23, 1985 was drained or otherwise manipulated for the purpose or having the effect of making production of an agricultural product possible. An area is no longer considered prior converted cropland for purposes of the Clean Water Act when the area is abandoned and has reverted to wetlands. Abandonment occurs when prior converted cropland is no longer used for or in support of agricultural purposes at least once in the immediately preceding 5 years. I want to note that currently the agencies may find PCC no longer meeting this exclusion, either if it's abandoned or if the use has been changed. We're soliciting comments on this change of whether we should follow an abandonment principle or a change in use. We're also soliciting comments on what agricultural purposes comprises, and we certainly want to ensure that there are no disincentives for enrolling in conservation programs. The agencies are proposing to clarify our longstanding view that the exclusion for artificial irrigation would only apply to the specific land being directly irrigated, which would revert to upland should artificial irrigation cease. We're proposing to specifically include cranberry and rice growing into this exclusion because this is about irrigated agriculture. Many rice and cranberries were historically covered under the exclusion for artificial lakes and ponds, and so we are soliciting comment on this particular change. The agencies have a long-standing exclusion for artificial lakes and ponds. In this proposal, we are highlighting for clarity that we would include farm ponds, log cleaning ponds, and cooling ponds that are constructed in upland under this exclusion. We are also proposing to clarify that these ponds are jurisdictional if they meet the lakes and ponds category or if they are impoundments. Unlike pre-2015 practice, the agencies do not propose to require the exclusive use of the artificial pond or lake, as we recognize that these features can have many different uses, but that doesn't change their status under the Clean Water Act. Another long-standing exclusion is for water-filled depressions created in the upland. These are often created incidental to mining or construction activities or for sand and gravel operations, and which we reflect in this proposed exclusion. If they are abandoned, the agencies would not consider them to be waters of the U.S., which may have happened under pre-2015 practice, but not under the 2015 rule. The exclusion for stormwater control features applies to those excavated or constructed in upland to convey, treat, infiltrate, or store stormwater runoff. These features may be point sources. Natural streams and rivers or lakes and ponds that may be incorporated into a stormwater management system would not be excluded under the proposed rule so long as they meet the proposed definition of tributary or lakes and ponds. If a ditch is constructed to serve as part of this stormwater control system, that ditch would be evaluated under the ditch category rather than as part of this exclusion. I do want to point out that the agency's proposal is similar to the 2015 rule and pre-2015 practice. We also don't want to be creating disincentives for green infrastructure and controlling stormwater runoff, and so we solicit comment on all aspects of this exclusion. Similar to the 2015 rule, the agencies are proposing to exclude wastewater recycling structures constructed in uplands. We are clarifying that this exclusion also applies to water recycling and reuse facilities constructed in upland. And again, we want to avoid discouraging or creating barriers to water reuse and recycling projects across the country. The last exclusion that the agencies are proposing is for waste treatment system. This is a long-standing exclusion from the definition of waters of the U.S. A key change in this proposed rule is that we are now providing a definition rather than relying on preamble language to describe what a waste treatment system entails in order to provide for regulatory certainty and predictability. And we are particularly interested in comments on this proposed definition, which is found on your slide. As with our long-standing practice, waste treatment systems may be point sources, and if a waste treatment system is abandoned or otherwise ceases to serve as a waste treatment system, it would no longer qualify for the exclusion if it otherwise meets one of the 6 categories of waters of the U.S. So to recap some general points about the proposed exclusions, where certain excluded features may convey perennial or intermittent flow to a downstream water of the U.S., they may serve as a connection. This does not make the excluded feature a water of the U.S. itself. It just means that it would not be severing the jurisdiction of that upstream water. We do have a proposed definition of upland, which is then applied to a number of these exclusions. To meet the exclusion, the feature would need to be constructed wholly in upland. The mere interface of an excluded feature, such as a non-jurisdictional ditch with a water of the U.S., for example, a tributary, does not then make that excluded feature jurisdictional. And finally, some of these excluded features may be point sources and require discharge permits. In the 4th section of the preamble, the agencies are soliciting comments on an idea based on interest we received during our pre-proposal outreach of enhancing geospatial data tools and leveraging existing experience of states, tribes, and other federal agencies to map jurisdictional waters so that landowners and others could better understand what may or may not be a water of the U.S. The agencies continue to post approved jurisdictional determinations on our website so the public can see on a map at a high resolution where the agencies have made determinations since August 2015. I do want to point out that there are no existing maps of waters in the U.S. across the country. So this would be an effort to provide greater clarity for the public of where waters in the U.S. may be found. This section of the preamble describes how we could possibly create a framework to enable states, tribes, and other federal agencies with an interest to develop geospatial data sets of waters following the rule text. The EPA and the Corps would then approve these data sets if they met certain criteria, and then the data sets would be made publicly available. We are still in the early stages of exploring existing data sets and capabilities, as well as seeking public comments on a range of issues. To supplement our proposed rule, the agencies developed a resource and programmatic assessment and an economic analysis. These two documents complement each other to provide the public with our assessment of potential effects of a new definition of waters U.S. Both of these documents are found in the docket as well as up on our website. The resource and programmatic assessment looks at available data, largely from the Corps of Engineers, to evaluate changes to categories of waters when comparing the proposal against the 2015 rule and pre-2015 practice. In both the resource and programmatic assessment and the economic analysis, the agencies discuss various data limitations and the challenges we faced when attempting a quantitative assessment of the potential change in jurisdiction, and we're concerned with these technical limitations. We then walk through potential effects across Clean Water Act programs and other programs that could be affected by a change in this definition, including the Safe Drinking Water Act and the Resource Conservation and Recovery Act. Finally, we have made an effort to summarize state laws and regulations so that we can better understand where they are currently regulating waters that may be newly non-jurisdictional and where they may not be. These analyses then feed into our economic analysis. And of course, we recognize that the agencies may not have gotten all of the details on state and tribal programs complete. And so we definitely encourage states and tribes to provide us with information in your comments so that we can enhance our analyses. For the economic analysis for the proposed rule, we intend to evaluate the potential costs and benefits associated with the change in the definition when compared to the primary baseline of the 2015 rule and the alternative baseline of the pre-2015 practice. The economic analysis breaks up the analysis into two parts to make the best use of available data. We encountered several data limitations that would not allow for a single analysis, which is explained in greater detail in the EA. The Stage 1 analysis is quantitative. It uses the 2015 economic analysis as a starting point and then incorporated existing state laws and programs and other enhancements to assess these potential effects. We acknowledged in the 2015 rule that we did not factor into the analysis how states were or were not regulating waters that would be newly jurisdictional, so we are doing that now. We also relooked at the wetlands benefits and have improved that analysis for this proposed rule. The Stage 2 analysis is a largely qualitative look at the potential impacts, considering how the proposed rule could affect regulated entities. It's qualitative due to the data limitations that I mentioned, and we have then developed 3 case studies across the country to assess effects across the oil spill, NIPDs, and 404 dredged and fill permit programs. And finally, we developed national estimated ranges of cost savings and foregone benefits for only the 404 program based on available data. So as I mentioned, our Step 2 proposed rule was signed on December 11th and was published today in the Federal Register. The Federal Register notice is available on our website, and that link is available on this slide, as well as the additional information and documents related to the proposed rule. As John noted in the beginning, the 60-day public comment period closes on April 15th of this year. Written comments can be submitted via the public docket and submitted through regulations.gov. The agencies are soliciting comment on all aspects of the proposed rule, the resource and programmatic assessment, and the economic analysis. And as I mentioned before, the preamble and supporting documents highlight specific issues and considerations for comments, but obviously we welcome all comments across all these documents. The agencies will hold a public hearing on February 27th, beginning at 4 p.m. Central Standard Time and concluding no later than 8 p.m. And then we'll pick up again on February 28th, beginning at 9 a.m. and concluding at 12 p.m. We're holding this at the Reardon Convention Center in Kansas City, Kansas. For additional information and to register, I encourage you to visit our website and clicking on the link found on this slide. The last day to pre-register to speak at the hearing will be February 21st. Additionally, requests to speak will be taken the day of the hearing at the hearing registration desk, pending availability. So to stay current, please visit EPA's WOTUS rule website. And this concludes our presentation. John?
Thank you, Mindy. I will now turn the webinar to Mr. Lee Forsgren and to Mr. Ryan Fisher for some final closing thoughts. Lee?
I want to again say thank you for everyone for taking the time to be involved in this webcast today. In addition to the webcast, which will be recorded and posted on our website, the agencies do plan to have a public hearing on February 27th and 28th in Kansas City, as well as meetings with our co-regulators, states and tribes in Kansas City, Atlanta, and Albuquerque. We look forward to continued conversations and a robust public comment period. Finally, I'd like to give the opportunity to the Department of Army if they have any final remarks.
Yeah, thanks, Lee. This is Ryan Fisher. Don't really have any final things to say other than we're working quickly but deliberately on these matters, and I certainly echo your commitment to clarity and transparency, especially with an eye towards implementation going forward. So thanks again for all who joined today.
Great. Thank you, Lee. Thank you, Ryan. And especially thank you, Mindy, for reviewing the presentation today. At this point, we'll now conclude today's webcast. Thank you again.